It was just 4 years ago that the Supreme Court legalized same-sex marriage, and some Americans believe that the fight for LGBTQ was finally won, but in the workplace, they continue to fight. The ruling for gay marriage did not address all the ways that LGBTQ individuals face discrimination. Same-sex folks can legally marry, but in some states, they still can be fired for being gay. So the Supreme Court, I understand, is hearing less than a handful of cases on whether it is legal to fire individuals, fire workers because of their sexual orientation or because their identity, their gender identity. Now, some people watching this say this is setting the stage for a landmark civil rights ruling. Joining me on the wall is attorney Byron Henry. He's an expert in federal law. What do you know about these cases that floated all the way up to the Supreme Court that are work-based, Byron?
Well, the issue here is not so much of where the country has come on the issue, Sergio. It's what the civil rights law dealing with discrimination in employment meant decades ago when it was passed.
Okay.
As you know, there's been the Civil Rights Bill, including the Discrimination Act, Title VII, allows employers, basically at-will employees, to be fired for any reason or no reason at all, except for what's called the prohibited reasons. And setting aside all the state laws on that issue or city ordinances, at the federal level, the federal law lays out categories of reasons you cannot terminate or take adverse action against an employee: nationality, ethnicity, race, sex, marital status, I think, or familial status, such as whether or not you're pregnant or whatnot.
Okay.
A couple other things. Religion, of course. So now we're going back to when that was passed, and it has always been understood that the sex in sex meant based on your gender. So sexual harassment cases that arise under that statute deal with treating women differently than men by harassing them or creating a hostile work environment for women, or firing someone or hiring someone either on a quid pro quo or whatnot because they're a man or a woman. What the cases are now saying is the because of sex is broader than what was traditionally understood. It includes sexual orientation, which it's a two-edged sword here. One, you could make a good argument that just in the normal run-of-the-mill, does because of sex include sexual orientation? Answer, yes. Problem is the Congress didn't think so because they've attempted to amend the statute to add sexual orientation on a number of occasions, and they have all failed. Argument being, if it already protects sexual orientation, why is Congress having hearings and trying to amend it and it failing if it's intended to cover sexual orientation?
Okay.
So the real struggle is what does that because of sex mean, and how broad is it? Is it gender, or does it mean more than that?
The makeup of the court, the way it is now, do you think this original intent argument and defense, do you think that holds up, or do you think this court will move and latch the LGBT community to the sex argument?
Interestingly, I would normally say that this court, the way it's currently composed, would tend to lean towards allowing Congress to amend statutes to include additional protections if it wants to, and not to read more into the statute than was there originally. Mm-hmm. But there is an interesting textual argument for this statutory construction case that I think has some weight. So if one of the conservative justices, or one of the more liberal justices who tend to hew towards textual reading of statutes, say for instance Justice Elena Kagan, cling to or latch on to that textual argument, it provides a legitimate basis to find that the statute by its terms covers sexual orientation, regardless of what Congress thought it did. So normally I would tell you that there's probably a 75-80% chance this is going to be found to not cover sexual orientation. But because of that, I tend to still think that the better argument is the original intent of Congress in the language, but there is a strong argument, and I would say this is a toss-up case. You only have to convince one of the conservatives, by the way.
Well, that's true.
You only have to convince Kavanaugh or Roberts, who dissented strenuously in the same-sex marriage cases. So to the extent someone is looking for Justice Roberts to extend an olive branch to the LGBT community, it may be time for that, but he has not shown any inclination in the past in doing so. So what you may be looking at is a Kavanaugh or a Gorsuch, possibly, new members of the court that were not there when the same-sex marriage decision came down. If they latch on to this textual argument for the because of sex language instead of because of gender, because it doesn't say gender, it says sex. The other side is basically sex always meant gender in the statute, and so we win. So it's a pretty good argument. But there's another argument that has some weight, and I think this is a 50-50 case since you only have to turn one justice.
All right. Federal Law Pro attorney Byron Henry joining me on the wall. Well, let's say, let's do some fantasy legal baseball now. Let's say the textual on the sexual is recognized. Okay, we wake up the following morning. What then does the law of the land say to Christian schools, daycares, hospitals, any religious organization says, no, we don't hire folks of that sexual orientation or whatever, because, you know, that goes against our way of life, our belief. We don't recognize that. Are they now breaking the law? Or you see a whole new series of religious freedom cases that might have to float up to the high court again to protect that point of view?
Well, I'm not saying that's not going to be an issue, but there are already state laws which cover sexual orientation, and there's also the federal law protecting a federal constitution and federal law protecting free exercise of religion. So the balance is most of these statutes have exceptions for religious organizations. So most of them have. Now, you're going to get into a fight over what's a religious organization. Is it making money, or is it just like a church? But generally, right now, there is an exception for, in federal law, churches.
And under the Civil Rights Law,
like
under
that.
the Civil Rights Act, there's exception there for churches?
Well, there are, for instance, a church can turn down applicants for a pastor that's a woman. Generally, that would be against federal law,
okay.
But if the church doesn't recognize female institutional leaders such as pastors or ministers, then a church does not have to hire an applicant that's a woman in any other industry other than a religious organization. That would be against federal law.
Okay.
But so there are already exceptions built in for religious organizations in some instances. I expect those would apply with equal force here, because even the people that on the court, the justices that were for same-sex marriage, made comments both in the opinion and in oral arguments that you wouldn't have to, for instance, marry people in your church if your church was against same-sex marriage.
Thank you, Byron. Attorney Byron Henry, my guest on the wall.